The first document arrived on a Thursday, not in the mail, hand-delivered. A courier in a company vest who asked for a signature at the door and left without making eye contact. The envelope was thick, professionally sealed, the kind that comes from an institution that has spent money on the presentation of bad news. Marcus Hale was 44 years old. He had been farming 310 acres in central Nebraska since he was 26. Not inherited land. Purchased. He had bought the first 160 acres himself, with money he had saved over 7 years of working 2 jobs and farming a smaller rented parcel on the side. He had added the remaining 150 acres 8 years later when the adjacent property came available, and the numbers worked if he financed carefully. He was not a man who did things carelessly. He read the courier envelope at the kitchen counter. It was a formal notice from Heartland Agricultural Lending, the institution that held his farm loan. The notice informed him that following a comprehensive portfolio review, his account had been identified as carrying terms that were inconsistent with current lending standards. Effective 60 days from the date of the notice, his interest rate would be adjusted from the fixed rate, specified in his original agreement, to a variable rate tied to a market index. Marcus read that paragraph 3 times. Fixed rate. Those were the words in his original agreement. Not variable, not adjustable. Fixed. For the full term of the loan. He set the envelope on the counter. Then he went to the filing cabinet in the back room and took out a folder, not to look at the original agreement. He already knew what it said. He took it out because he wanted to look at something else. Something he had noticed 2 years earlier and had filed carefully without mentioning to anyone. Document number 1. Marcus Hale had not always been a careful man with paper. In his 20s, he had kept records the way most young farmers kept records, which was to say imperfectly in a general way, trusting that the important things would be findable when they needed to be found. That approach had cost him once. Early on, in a dispute with an equipment supplier over a warranty claim, he could not prove because he had not kept the paperwork. The amount was not large. The lesson was, after that he kept everything. He had signed his first loan agreement with Heartland Agricultural Lending in 2006. A standard agricultural mortgage, fixed rate, 30-year term, same payment every month. He had read every page before signing. He had kept the signed copy in a folder marked Heartland Loan. Original 2006. In 2014, when he purchased the additional 150 acres, he had refinanced through the same institution. New agreement, new terms, still fixed rate, which had been the condition he had insisted on, and which the loan officer at the time, a man named Gerald Purcell, who had since retired, had confirmed in writing. He had kept that agreement in a folder marked Heartland Loan. Refinance 2014. Both folders were in the filing cabinet in the back room. He had looked at both of them in 2022, not because anything had gone wrong, but because Heartland Agricultural Lending had been acquired by a larger regional institution called Consolidated Rural Finance Group. And Marcus had made it a habit to review his agreements whenever the institution holding them changed hands. During that review, he had noticed something. The refinance agreement from 2014 referenced an addendum. Page 12. Subsection 4. A note that certain terms of the agreement were subject to an attached rate schedule addendum. Document reference CRF 2044-447. Marcus had read that line in 2022 and looked for the addendum in the folder. It was not there. He had called Heartland, which by that point had become Consolidated Rural Finance Group, and asked about document CRF 2044-447. The representative had put him on hold for 11 minutes. When she came back, she said she could not locate that document reference in their current system. Marcus had noted the date of that call in his records. Then he had waited. Because a missing addendum on an active loan agreement was not a problem yet, but it was the kind of thing that became a problem, eventually. 2 years later, the courier arrived at his door, and Marcus Hale went to the filing cabinet and took out document number 1. Document number 1 was not the loan agreement. It was a letter dated March 14, 2014, written on Heartland Agricultural Lending letterhead. Signed by Gerald Purcell, loan officer, in the handwriting Marcus had seen on a dozen documents over the years. The letter confirmed, in plain language, that the refinance agreement being executed that day contained a fixed-rate provision for the full term of the loan, and that no variable rate adjustment mechanism was included in or attached to the agreement. Gerald Purcell had written it at Marcus's request on the day of signing. Marcus had asked for it because he wanted something in plain language, not loan agreement language, confirming what he had been told verbally. Purcell had written it without hesitation. Marcus had kept it in the folder marked Heartland Loan. Refinance 2014, behind the agreement itself. He read it now at the kitchen counter beside the courier envelope. Fixed rate provision for the full term of the loan. No variable rate adjustment mechanism included in or attached to the agreement. He set it down. Then he called his neighbor, a woman named Beth Crowley, who farmed the adjacent property and whose husband had been a banking attorney before he retired. Beth's husband, Carl, was 62 years old and no longer practiced, but still read every financial document that crossed their kitchen table, out of what he described as professional habit. Marcus asked if Carl would be willing to look at something. Carl said to come over. Carl Crowley read the courier notice first, then the 2014 loan agreement, then Gerald Purcell's letter. He read each one completely before moving to the next, the way he had read documents for 30 years, without commenting until he had finished all three. When he finished, he set them on the table in the order he had read them. He said, "The notice references a rate adjustment mechanism." He tapped the courier envelope. "Your loan agreement contains a fixed rate provision." He tapped the 2014 folder. "And this letter confirms no adjustment mechanism was included." He tapped Purcell's letter. Marcus said, "They're saying the addendum changes that." Carl said, "What addendum?" Marcus said, "Document CRF 244447. It's referenced on page 12 of the refinance agreement." He paused. "I've never seen it. I called them in 2022 and they couldn't find it either." Carl looked at him. Marcus said, "I think they're trying to enforce a term from a document that may not exist." Carl was quiet for a moment. Then he said, "Do you have your 2006 agreement as well?" Marcus said yes. Carl said, "Bring it." Marcus brought the folder marked Heartland Loan. Original 2006. Carl opened it and turned to the terms section. "Read it carefully." Then he looked at the 2014 agreement again. He went back and forth between the two documents several times, comparing specific sections. After a few minutes, he set both folders down. He said, "Marcus, your 2006 agreement has no addendum reference anywhere. Your 2014 refinance agreement references an addendum on page 12. That addendum was not provided to you at signing. It does not appear in your copy of the agreement. And when you asked the institution about it 2 years ago, they could not locate it either." He paused. He said, "They are now attempting to enforce a rate change they claim is authorized by an addendum that neither you nor they can produce." Marcus said, "Can they do that?" Carl said, "That is exactly the right question, and the answer is no. An addendum that was never provided to the borrower, never signed by the borrower, and cannot be produced by the lender, is not an enforceable part of the agreement." He looked at Purcell's letter. He said, "And this letter makes it worse for them, because it explicitly confirms that no variable rate mechanism was included, which means either the addendum was added after signing without your knowledge, or it never existed and they are inventing it now." Marcus looked at the three documents on the table. Carl said, "You need a lawyer, not tomorrow." Today, her name was Diane Howell, 48 years old, Lincoln, Nebraska. 22 years of agricultural banking law, the kind of lawyer who spoke in complete sentences and never used a word she did not mean precisely. Marcus drove to her office the following morning. He brought the courier notice, the 2006 agreement, the 2014 refinance agreement, and Gerald Purcell's letter. He also brought something else. Document number 2. Document number 2 was the record of his 2022 phone call. Not a note about the call, the actual record. Marcus had developed a habit, after a frustrating dispute with an insurance company in 2018, that came down to his word against theirs, of recording his own calls with financial institutions. Nebraska was a one-party consent state. He had not hidden the recording. He had simply made it. The 2022 call in which the Consolidated Rural Finance Group representative had told him she could not locate document reference CRF 20447 in their current system was 23 minutes and 41 seconds long. Marcus had the recording on his phone and a typed transcript he had made himself. He placed the transcript on Diane's desk beside the other documents. She read the transcript. Then she read Purcell's letter. Then she went through the 2014 agreement and found the addendum reference on page 12. She set everything down. She said, "Mr. Hale, walk me through the sequence." He did. She listened without interrupting. When he finished, she said, "Let me make sure I understand what we have." She touched each document as she named it. A 2006 original agreement with fixed-rate terms and no addendum reference. A 2014 refinance agreement with fixed-rate terms and a single addendum reference on page 12. A letter from the signing loan officer confirming no variable rate mechanism was included, and a recorded call from 2022 in which the institution confirmed they could not locate the reference addendum. She looked at Marcus. She said, "And now they are attempting to enforce a rate change they claim the missing addendum authorizes." Marcus said, "Yes." Diane looked at the documents for a moment. Then she said, "I want to request their complete loan file, everything they have on this account going back to 2006. Every version of every document, every internal note, every system entry." Marcus said, "Can you do that?" She said, "Under Nebraska banking law, a borrower has the right to request their complete loan file from any institution holding their account. They have 30 days to provide it." Marcus said, "What are you looking for?" Diane said, "I want to see whether document CRF 2004-4447 exists in their file. And if it does, I want to see when it was created and what it says. And if it doesn't," she paused. She said, "then we have a very different conversation." She filed the request that afternoon. The loan file arrived on day 28, 412 pages. Diane's paralegal spent 2 days organizing it chronologically. Diane spent 3 days reading it. On the afternoon of the third day, she called Marcus. She said, "I found document CRF 244447. Marcus waited. She said, "It is a rate schedule addendum. 4 pages. It contains a variable rate adjustment mechanism tied to a market index." Marcus said, "So it exists." Diane said, "It exists." She paused. "It was created on September 4th, 2019. Marcus said nothing for a moment. Diane said, "Your refinance agreement was signed in March of 2014. This addendum was created 5 years and 6 months after you signed the agreement. It bears a reference number that appears in your 2014 agreement, but the document itself did not exist until 2019. Marcus said, "They added it after the fact." Diane said, "The metadata in their own document management system shows a creation date of September 4th, 2019. The document was not created at the time of your signing. It was created 5 years later and inserted into the file with a reference number that already appeared in your original agreement." The line was quiet for a moment. Marcus said, "Can you prove that?" Diane said, "They proved it themselves. It's in their own file." She paused. Document CRF 2014-447 was created in 2019. Your signed agreement from 2014 references it. That is mathematically impossible. Unless the reference was placed in the 2014 agreement in anticipation of a document that did not yet exist, or the document was backdated. She let that sit for a moment. Then she said, "Either way, it is not enforceable." Document number 3 was the metadata report. Diane's technology consultant pulled it directly from the file. Consolidated Rural Finance Group had provided a formal document authentication report showing the creation date, modification history, and system entry record for CRF 2014-447. Created September 4, 2019. First system entry, September 4, 2019. Referenced in Heartland Agricultural Lending Refinance Agreement, March 2014. 3 documents, 3 different years. 1 impossible timeline. Diane filed the formal response on a Monday morning. 61 pages. The 2006 original agreement. The 2014 refinance agreement. Gerald Purcell's letter. The transcript and recording of the 2022 phone call. And the metadata authentication report, showing that document CRF 2004-447 had been created 5 years after it was referenced in Marcus Hale's signed loan agreement. She filed it simultaneously with the Nebraska Department of Banking and Finance and the Consumer Financial Protection Bureau, along with the formal civil complaint in Lancaster County District Court. Consolidated Rural Finance Group received the filing on a Wednesday. Their legal department reviewed the metadata report on Thursday morning. By Thursday afternoon, their chief legal officer had scheduled an emergency call with outside counsel. By Friday morning, outside counsel had reviewed the complete loan file. By Friday afternoon, they had called Diane Howell's office. The call lasted 38 minutes. Deanne called Marcus that evening. She said, "They want to settle." Marcus said, "What are they offering?" She told him. He said, "What do you think?" She said, "I think we can do better." She paused. The metadata report is not just evidence of an unenforceable addendum. It is evidence of document fraud. And document fraud in a lending context carries regulatory consequences that are significantly more expensive than whatever they are offering you right now, Marcus said. "Then let's keep going." Deanne said, "I was hoping you would say that the hearing was held on a Tuesday morning in Lancaster County District Court." Consolidated Rural Finance Group arrived with 4 lawyers. Their lead counsel, a man named Preston Gale, had 20 years of banking litigation experience and had prepared extensively for the case. He understood the metadata report. He understood what it showed. He had spent 2 weeks trying to find an alternative explanation for a document creation date that was 5 years after the agreement that referenced it. He had not found one. Judge William Marsh had been on the Lancaster County bench for 17 years. He had read every page of the filing over the previous weekend. When he entered the courtroom, he arranged his papers with the particular care of a man who has already formed a view and is about to explain it. Preston Gale spoke first. He was skilled and he was thorough, and he did the best he could. He argued that document management system metadata was not always reliable. He argued that the addendum may have been created as a replacement for an original document that had been lost during the 2019 migration. He argued that the intent of the original agreement had always included the rate adjustment mechanism. He spoke for 31 minutes. Judge Marsh listened without expression. Then he turned to Diane Howell. Diane stood. She placed 3 documents on the bench. Gerald Purcell's letter from 2014, confirming no variable rate mechanism was included. The transcript of the 2022 phone call in which the institution confirmed they could not locate the addendum. And the metadata authentication report showing document CRF 2004-447 was created on September 4, 2019. Then she said 4 sentences. The signing loan officer confirmed in writing that no variable rate mechanism was included. The institution confirmed in a recorded call that they could not locate the referenced addendum. Their own document management system shows the addendum was created 5 years after the agreement that references it. There is no version of those 3 facts that supports enforcing this rate change. She sat down. Judge Marsh looked at the 3 documents for a long time. Then he looked at Preston Gale. He said, "Counselor, your client's own file shows this document was created in 2019. Your client's own representative confirmed in a recorded call in 2022 that they could not locate it. And your client's own loan officer confirmed in writing in 2014 that no such mechanism existed." He paused. He said, "Which of those 3 things does your client dispute?" Preston Gale looked at his notes. Then he said, "Your Honor, we would ask the court to consider." Judge Marsh said, "Which of those 3 things does your client dispute?" A long silence. Preston said, "None of them, Your Honor." Judge Marsh looked back at his papers. The rate adjustment notice issued to Marcus Hale is void. The original fixed-rate terms of the 2014 refinance agreement remain in full effect for the duration of the loan. He picked up his pen. Consolidated Rural Finance Group is found liable for attempted enforcement of a fraudulent loan addendum. Damages are awarded at $387,000, including statutory penalties, legal costs, and compensation for documented financial disruption. He set the pen down. Furthermore, this court is referring the document creation and dating practices of Consolidated Rural Finance Group to the Nebraska Department of Banking and Finance and to the Office of the Nebraska Attorney General for formal investigation. He closed the file. In the 3 years since the 2022 acquisition, Consolidated Rural Finance Group had reviewed and modified LaFlau files across a portfolio of 48,000 accounts. The investigation would determine how many of those files contained addenda with creation dates that did not match the agreements that referenced them. Marcus did not stay for that part. He shook Diane's hand, thanked her, picked up his jacket. Then he drove home on the same highway he had driven every day for 18 years, past the same fields, the same fence lines, the 310 acres that were still exactly what they had always been, his. He parked outside the farmhouse and sat in the truck for a moment. He thought about the courier envelope that had arrived on a Thursday, about the 412-page loan file, about a document created in 2019 with a reference number that appeared in an agreement and signed in 2014, about Gerald Purcell, a retired loan officer who had written one clear, honest letter in 2014 because a young farmer had asked him to put something in plain language. That letter had cost Purcell nothing. It had cost Consolidated Rural Finance Group $387,000 and a federal investigation. Marcus got out of the truck. He went inside, made coffee, and sat at the kitchen table. Outside the window, the Nebraska fields were quiet in the late afternoon light. Same fields he had planted at 26, with money saved over 7 years. Same fields he would plant again in the spring, because that was what the land required. And Marcus Hale had never once given it anything less. If this story meant something to you, subscribe. Hit the bell. We will be here when the next one drops.